Good evening. If you could please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. I want to welcome you to the October 14th, 2019 Zoning Hearing Master Hearing. My name is Susan Finch, and I will be presiding as the hearing officer over tonight's cases. Let me start by introducing Mr. Brian Grady, who's at the end of the dais with the Development Services Department, who will go over, introduce the other members of the dais this evening and go over our changes. Mr. Grady.
Good evening, Ms. Finch. Again, for the record, Brian Grady, Hillsborough County Development Services. Before I go through the changes to the agenda, joining us at the dais tonight, or to my left, Lewis Whitehead with the County Attorney's Office. To his left, Joanne Haley with the Hillsborough County City-County Planning Commission. And to her left, Tom Hisney with Development Services. Tom will be handling the special use cases on tonight's agenda. We have three changes to the published agenda. The first change is on page 11, item E3. It's rezoning application PD 19-0838. The applicant's DMD support group. The applicant is requesting a continuance to December 16, 2019 zoning hearing master hearing. I believe the applicant is here to explain the reasons for the requested continuance.
Good evening.
Good evening, Ms. Finch. For the record, I'm Michael Horner, 14502 North Dale Mabry Highway, Tampa, representing the applicant. We're working through some EPC issues. We have staff recommendations based on a few transportation issues as well. And I think this continues to be best served for all of us to get back together and try to work through these issues.
All right.
We're asking for December hearing.
It's my next question. So that you believe that's sufficient time to resolve the issues?
I do.
Okay. Then is there anyone here that would like to speak to the continuance for agenda item E3, rezoning 19-0838? Just speak to the continuance only. All right. Seeing no one, then we will continue rezoning PD 19-0838 to the December 16th, 2019 zoning hearing master hearing at 6 p.m. Thank you.
The next change is also on page 11, item E5, rezoning application PD 19-1037. The applicant is Tampa Bay Community Church Incorporated. The applicant is requesting a continuance to the November 18th, 2019 zoning hearing master hearing.
Good
Ms.
evening.
Finch, good evening again. Michael Horner, 14502 North Dale Mabry Highway, Tampa, representing the applicant. We are close to final conditions being accepted. There's a gate issue that we're still negotiating over with our client and staff, and we're just asking for a 30-day continuance.
All right. Is there anyone here that would like to speak to the continuance of agenda item E5, rezoning PD 19-1037? Seeing no one, we'll continue that item, rezoning PD 19-1037 to the November 18th, 2019 zoning hearing master hearing at 6 p.m.
And the final change on the agenda is on page 12, item E7, rezoning application PD-19-1099. The applicant is Elise Batzel. The applicant is requesting a continuance to the November 18th, 2019 zoning hearing master hearing. But the applicant is here to explain the reasons for the request.
Good evening.
Good evening, Elise Batzel, 401 East Jackson Street. We're working through some EPC issues as well with both staff and EPC. In addition, we held a community meeting last week, and we would like some time to address their concerns on the site plan and to modify the site plan, and we believe that November 18th will give us enough time. We did make an announcement at the community meeting that we would be continuing, so hopefully there's no one here that doesn't have that information.
All right. We'll make sure right now. Is there anyone here that would like to speak to the continuance of rezoning PD 19-1099, if you could come forward, sir. And this is just to the item, to the issue of the continuance, not the merits of the case.
I understand.
Good evening. If you could give us your name and address.
Good evening. My name is DeWitt Craig Kemmer, and I live at 4408 Hickory Branch Court, Brandon 33511. And I'm here tonight representing the neighborhoods of Dogwood Hills, Hickory Creek, Hickory Woods, and many other interested parties along the John Moore corridor, and also many interested parties in South Brandon and South Valrico areas. And we're here tonight to support this continuance.
Perfect. Thank you very much. If you could please sign in with the clerk's office. Thank you for coming down. I appreciate it. Anyone else that would like to speak to the continuance of this item? All right, seeing none, we will continue agenda item E7, rezoning PD 19-1099 to the November 18th, 2019 zoning hearing master hearing at 6 p.m. Thank you so much.
I will now go through the published withdrawals and continuances beginning on page 5 of the agenda. The first item is item A1, RZPD 18-1037. This application is being withdrawn from the zoning hearing master process. Item A2, SU General 19-0833. This application is being withdrawn from the zoning hearing master process. Item A3, RZPD 19-0837. This application is being withdrawn from the zoning hearing master process. Item A4, Major Mod Application MM 19-0521. This application is being continued by the applicant to the November 18, 2019 zoning hearing master hearing. Item A5, RZPD 19-0655. This application is being continued by staff to the November 18, 2019 zoning hearing master hearing. Item A6, RZ Standard 19-0747. This application is out of order to be heard and is being continued to the November 18, 2019 zoning hearing master hearing. Item A7, RZ Standard 19-0748. This application is out of order to be heard and is being continued to the November 18, 2019 zoning hearing master hearing. Item A8, Special Use General 19-0834. This application is being continued by staff to the November 18, 2019 zoning hearing master hearing. Item A9, RZPD 19-0929. This application is being continued by staff to the November 18, 2019 zoning hearing master hearing. Item A10, SULE 19-1026. This application is out of order to be heard and is being continued to the November 18, 2019 zoning hearing master hearing. Item A11, MM 19-1140. This application is out of order to be heard and is being continued to the November 18, 2019 zoning hearing master hearing. Item A12, RZPD 19-1163. This application is out of order to be heard and is being continued to the November 18, 2019 zoning hearing master hearing. Item A13, SU General 19-1165. This application is being continued by staff to the November 18, 2019 zoning hearing master hearing. Item A14, RZPD 19-1168. This application is being continued by staff to the November 18, 2019 zoning hearing master hearing. Item A15, MM 19-1169. This application is being continued by the applicant to the November 18, 2019 zoning hearing master hearing. Item A16, MM 19-1172. This application is being continued by the applicant to the November 18, 2019 zoning hearing master hearing. Item A17, RZPD 19-1173. This application is out of order to be heard and is being continued to the November 18, 2019 zoning hearing master hearing. Item A18, RZPD 19-1205. This application is out of order to be heard and is being continued to the November 18, 2019 zoning hearing master hearing. And item A19, RZPD 19-1296. This application is out of order to be heard and is being continued to the November 18, 2019 zoning hearing master hearing. That concludes all withdrawals and continuances. One other program note, Ms. Finch, the two remand items, which were B1 and B2, since they're both being heard by you, we typically put those in the beginning of the agenda because different hearings officers may be hearing that. But since you heard both those cases, I would recommend and suggest that we normally hear the special use applications first. So I would suggest we hear the C items, C1, C2, C3 first, and then go to the rezoning items, which will be beginning with B1.
All right, I agree. Thank you so much. I appreciate it. So just to make sure everyone got that change, especially the two remands that are first. We're going to start with the special use applications, and then when we're done with that, we'll go back to the remands. Let me start by going over our procedures tonight, which are informal. As Mr. Grady said, we are going to start with the special use applications, then go to the remands. The special use applications require a hearing before a land use hearing officer, and a decision is made 15 business days following tonight's hearing. The remainder of the items require a hearing before a zoning hearing master before a final decision who is made by the Board of County Commissioners. We'll conduct the hearing tonight, and I will make a recommendation within 15 business days following tonight's hearing. That recommendation is then filed with the Board of County Commissioners, who make the final decision. Our hearing tonight is informal. I'll ask questions related to direct testimony presented tonight. I'll call and question witnesses as I deem appropriate, and will decide all questions of procedure. Irrelevant, immaterial, or unduly repetitious evidence will be excluded. Any part of the evidence may be received in written form, and all testimony must be under oath. Hearsay evidence may be used for the purpose of supplementing or explaining other evidence, but shall not be sufficient in and of itself to support a finding by me unless it would be admissible over objections in a civil action. Our order of presentation tonight is as follows. Mr. Grady of the Development Services Department will provide a brief introduction of each agenda item. We'll then go to the applicant. The applicant and their entire team has a total presentation time of 15 minutes. We'll then go back to the county's Development Services Department staff planner that was assigned the case, and they will have 5 minutes to present the county's findings. We'll go to the Planning Commission, who also has 5 minutes to explain consistency with the county's comprehensive plan. We'll then go to proponents, anyone who would like to speak in favor of an item. Total proponent presentation time, 15 minutes. The same is true when we go to opponents, anyone who would like to speak against an application. Everyone has 15 minutes total. We'll go back to the county staff, who has 5 minutes to address any issues or make any changes to conditions or so forth they deem necessary. And then finally, we'll go back to the applicant, who has 5 minutes for rebuttal. I'm not sure we have this issue tonight, but just to put it on the record, the 15 minutes for proponents and opponents is total. So if you want to identify a spokesperson to get all your testimony in, you can do it that way. It's a good use of your time. Or if everyone wants to speak individually, I'll ask for a show of hands of how many people want to speak, and we will divide that 15 minutes up per person. When you come up, if you are going to speak, make sure you speak clearly into the microphone. We are recording this hearing audibly as well as on video. And start by giving us your name and address for the record. When you are done speaking, if you could see Allison, raise your hand, as she's at the clerk's office. You need to also then go over to her and sign in with your name and address to make sure we have it accurately spelled for the record. She is also who you would give, if you want to submit any items into the record, you give them to her, and that ensures that you have submitted it in the proper format. Now, because we're going to start with the special use items, I'll have Mr. Whitehead of the County Attorney's Office explain your procedure for the right to appeal special use decisions. Mr. Whitehead.
Thank you, Madam Hearing Officer Louis Whitehead, Assistant County Attorney. The hearing officer's decisions on special uses heard tonight will be filed with the clerk of the board on November the 4th. The Land Development Code provides that anyone who desires to receive a copy of the decision by mail must furnish the clerk of the board with their name, address, the case number, and a stamped self-addressed envelope. Decisions of the hearing officer on special uses may be appealed to the Land Use Appeals Board. An appeal must be filed with the Development Services Department within 30 calendar days from the date that the hearing officer's decision is filed with the clerk of the board. A decision of the hearing officer may be appealed by or intervened in by a person who is present or represented at tonight's hearings and presents either testimony or documented evidence or submitted documentary evidence themselves or through another prior to or during tonight's hearing and is adversely affected by the hearing officer's decision. The evidence that the appeals board can consider is limited to the evidence that is presented tonight. This means that at the end of tonight's hearing on each special use, the case record closes and no new evidence may be submitted. The county attorney's role is to make sure that no additional information is considered by the appeals board. So please be sure that all information that you may desire the appeals board to consider is placed in the record tonight. Thank you very much.
Thank you, Mr. Whitehead. I appreciate it. As I mentioned, all testimony must be under oath. So if you plan to speak tonight, if you could please stand and raise your right hand, and I'll swear you in. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated. Mr. Hisnay, if you could please call the first case.
First special use tonight is item C1, application number 19-0957. The applicant is Mark Bentley, Esquire. The request is for a 2 COP alcoholic beverage permit which requires a distance separation. Staff report and recommendation will be presented by myself following the applicant's presentation.
Good evening.
Good evening, Ms. Finch. My name is Mark Bentley, 401 East Jackson Street, Tampa, 33602. I represent the property owner, Gas Quick Incorporated from Tampa, Florida. Before I get started, I have a few documents, a composite exhibit I'd like to go through to facilitate my presentation.
Okay.
So what I'll do is give one to the clerk and one to you and Tom.
Perfect. Thank you.
Having heard the variance request a few weeks ago, I realize you're somewhat familiar with the property. So the intention here is to develop a microbrewery on the property. Therefore, we're seeking waivers in connection with the 2 COP. Specifically, we're seeking distance separation waivers from residentially zoned property and a community use. So the first exhibit, if we take a look at, is an aerial photograph. You'll see the project site identified, and then I'll call that the north, Ms. Finch. That's the separation, the 193 feet. And then the second distance waiver is the community use. If you look to the southeast, you'll see south of Gun Highway, an area that appears to be a swimming pool and a tennis court. And that relates to the second waiver. The residentially zoned property is located to the north and is 53 feet from the wet zoned area. Community use is a secured private recreational facility owned by the Plantation HOA and is located 154 feet to the south of Gun Highway, which is considered on the long-range transportation plan as a major arterial roadway. The LDC standards for a waiver, which you're pretty familiar with, are number one, whether unique or special circumstances exist such that the proposed use does not have significant negative impacts on surrounding land uses. And the second is whether certain circumstances exist such that the necessity for the specified distance requirements is negated. First, there'll be no significant or no impacts whatsoever, let alone significant impacts on surrounding land uses. The closest residential property is to the north, which is 53 feet away from our building, the wet zone premises. There will be a type A screening per code along with existing trees identified in the survey I'm providing you, which is Exhibit 2, a tree survey. And you can see the northern property line. Also, any outside sales or consumption will occur away from the residential area closer to Gun Highway. And staff has suggested a condition that we're okay with that mandates that the area where outside sales and consumption can occur is the 55-foot southerly portion of the building and the property directed to Gun Highway.
That's on the patio portion?
Yeah, and if you take a look at Exhibit 3, Ms. Finch, you'll see the red shaded area says proposed patio. If you look directly to the right of that, okay, or to the south, that says grassy area.
Yes.
So they could have a game area, for example, out there and have sales and consumption in that area. But to the extent they can outside, it's 55 feet from the southern part of the wet zoned area.
I see.
And it's really 50 feet if you look at the site plan. Mr. Hisney came up with a good idea and an abundance of caution to allow some possible changes out in the field from 50 to 55 feet. So if we look at Exhibit 4, the closest community use is an area in Plantation that includes a swimming pool and tennis court. This is separated by a major arterial and screened by a masonry wall. In addition, the actual travel distance via the roadways and sidewalks would exceed the minimum 500 lineal feet. So if you take a look at Exhibit 4, the first one, Ms. Finch, you can see this is looking to the southeast, south of Gun Highway, You can see this is a totally walled area surrounding the plantation. In the second picture, what we did is we used county GIS, and there are two ways to get to the community use from the subject property, and we highlighted those, and you can see probably closer to a mile either way you get there. These are Exhibit 4. There's two sub-exhibits, I guess you could say. So having it being a private secured facility located south of a major arterial and the travel distance closer to probably a mile, we think that negates the separation requirements. So the circumstances demonstrate that the necessity for these distances is negated. And Exhibit 5 is a AB work map that we received from Development Services. And what you can see here is we've highlighted the subject property in kind of a purple. And there's an undeveloped gas station located to the south of the subject property that has a wet zoning of 2 APS. Then there's a strip center located directly north of and contiguous to the subject property that likewise has the 2 APS. So what we're proposing is not uncharacteristic for the subject area. And then there's a letter of support from owners of property located within 250 feet, and that's by Beth Montgomery, and they live approximately 180 feet away. So that's my presentation, and if you have any questions, I'll attempt to answer them.
I don't, but thank you for your testimony. I appreciate it.
You're welcome. Thank you.
Development Services, please.
Yes, the applicant's requesting a 2 COP alcoholic beverage permit, which requires 2 separation waivers. The permit is sought to allow the sale and consumption of beer and wine on and off the permitted premises in connection with a proposed brew on premises pub at the northwesterly corner of Gun Highway and Perez Drive. Property is zoned CG, which permits the proposed pub and consideration of the requested AB permit. There are 3 separation requirements in the Land Development Code for 2 COP wet zonings. 1, they must be at least 250 feet from residentially zoned property. 2, they must be at least 500 feet from certain community uses. And then lastly, there can be no more than 3 existing wet zonings of certain types within 1,000 feet. According to the survey that was submitted by the applicant, there are less than 3 existing wet zonings of certain types within 1,000 feet of the proposed wet zoning. These include 1 2-cop and 1 2-cop X. However, as stated by the applicant, the proposed wet zoning is less than 250 feet from residentially zoned property and less than 500 feet from certain community uses. The Land Development Code provides for the consideration of separation waivers where there are special or unique circumstances where the proposed alcoholic beverage use does not pose significant impacts on surrounding land uses in certain circumstances and negate the necessity for the specified distance requirements. In the subject case, nearby single-family homes to the northeast of the proposed subsite will be separated from the subject wet zoning by a 20-foot wide buffer with type A screening comprised of a 6-foot high fence, wall or hedge, and a row of evergreen shade trees that will be required for development of the pub or any other commercial use on this property. And this property is zone CG, and although the proposed use is a brew on premises pub, as a standard Euclidean zoning, if that development doesn't occur, then other uses that would be permitted by the CG district would be permitted here. But in all cases, there would be a 20-foot buffer with type A screening required along the north property line. Additionally, Perez Drive, adjacent to the site, is a short dead-end street that cannot be utilized as a through route by customers of the pub. As stated by the applicant, the pub plans has always depicted that the outside patron area would be restricted, located on the southern side of the site near Gun Highway, and would be separated from the residential uses to the north by the building. And this was always a good, important consideration in our staff review of this. However, again, because this is a standard district and development of the pub is not guaranteed, we felt that it was necessary to include a condition or a recommended condition for this wet zoning that would ensure that would happen no matter what the end user of the site would be. And then this condition was shared by the applicant prior to filing of the report, and he has stated that he concurs with this condition, which reads as follows: the outside sale and or consumption of alcoholic beverages shall be limited to the southwesternmost 55 feet of the wet zone area, which is exactly what is proposed, by the applicant. Also, there are 4 single-family homes on the south side of Gun Highway that are within 250 feet of proposed wet zoning, with the closest being 191 feet distance. These homes are separated from proposed wet zoning by a heavily traveled arterial road and are screened by a masonry wall. As for the community recreation facility on the south side of Gun Highway, this is also separated from the proposed wet zoning by a heavily traveled arterial road and screened by a masonry wall. Additionally, it's a private facility with restricted access. For the reasons stated above, staff finds the proposed wet zoning does not pose significant impacts on surrounding land uses, thereby negating the necessity for the prescribed separation requirements, and we find that it is approvable subject to the recommended condition.
Thank you so much. We'll call for anyone that would like to speak in favor. Anyone in support? Seeing no one. Anyone in opposition? Yes, ma'am, if you could please come forward. While she's coming forward, is there anyone else that would like to speak to this application? Good evening. You can give us your name and address, please.
Amelia Maines, 5812 Imperial Key, Tampa, Florida, 33615.
Thank you so much.
And I'm here speaking on behalf of all the owners of the houses directly behind on Perez. There's like one is mine, the one that's being built, and then there's 4 other houses. And their concern is it is not a complete dead-end street, Perez. Actually, you can go in and go around and come out to the other little street, which you don't have to turn, you can cross Gun Highway. Right now, the entrance to the brewery will be on Perez's side. It's on our road. And it really doesn't give us a lot of security that when people leave the brewery or the microbrewery, that they're going to be turning, left and not right, or, just by a sign, they're going to try to cut through the houses and come out to the smaller street and be able to cross Gun Highway without having to do a U-turn. And we've been trying to talk to them to some kind of a gate or something to give us security that people, I know it's beer and wine, but people are drinking, and it's a small street. It is not a very big street. It's a little private street that they don't go through there. Because it says dead end, they still might try to get through there, and there is an exit.
Let me make sure I understand. Is your lot, does it access, your access is Perez Drive?
Yes, I'm the one right directly behind where,
Because,
their fence will be with my yard, my house.
and so I have an aerial in front of me.
I don't have it.
Mr. Bentley provided. And there are 3, 4, 5, maybe 6 houses, 6 lots that access from Perez. Does that sound right? Tell me
It'll
where you
be-
are as you turn in off Gun Highway.
When you turn on Perez,
Yes,
you got their proposed site,
yes.
the next site,
Oh, right behind them.
right behind is
Understood.
mine. But
Okay.
all the residents are here from down the street, but we just have one person talking.
Okay.
But they're here, they're the one right directly next to me. There's only 1, 2, 3, 4, and mine, 5 houses.
I see.
And that Perez, I don't know the area, if you can see, it does go out. It goes around. It's not used a lot because there's only 5 houses there. Nobody goes in there.
And I have not been to the site yet, but it looks like it dead ends into 2 homes or the
No,
back of 2 homes?
You can actually keep and turn right, and it'll take you out to the other little street next to, before you get to Perez. I don't know if I see one, I could show you what it does, but I don't have an aerial with me here. If you want to, I could.
Mr. Hisney, can we supply her an aerial that she can show me on the Elmo? Just from the staff report?
I've got one,
Yeah.
If you don't mind, that would be wonderful. Thank you. Ma'am, if you want to come over here to the Elmo, there's a microphone, just so I can understand where you are and what the access issue you're describing. Thank you, Mr. Bentley. I appreciate it.
Okay, there's Gun Highway Perez, and it's, let me see, what, I gotta turn it.
That's fine.
Um,
And the property in question is what says project site.
Okay,
So
this
that's-
is, if you look at my finger, this is Perez, and then that right here is a little road that comes out to this street that will take you out to Gun Highway. Hubert, it would be out to Hubert. There is an exit from the last house you saw. It looks like it dead ends on that house. You turn right and it'll take you out to Hubert, and then Hubert doesn't have an island in between Gun Highway. You can turn right or left. But their exit, if they come out to Gun Highway from their exit on Perez, they gotta turn right, and do U-turns or do something else because they cannot cross the median. There's a middle thing.
Have you had an opportunity to speak to either the developer or their representative?
We have. We actually had a meeting with them. We asked them since if we could maybe work with them and with us putting some kind of a gate, because a sign doesn't really make sure that no one's going to be after drinking and stuff driving down this dark street, which is dark.
I'm sorry to interrupt, but your concern is that they would leave the site and turn left and past your home and then circle around to Hubert.
Right.
That's your concern? I
That's our
understand.
concern. So we wanted some kind of more physical thing that a gate, you can't get through it. But a sign saying don't turn, and you've been drinking, you've been, partying, you're not really paying attention. And that is a street where, the kids play and they're outside on Saturdays, and it is a very small street also. It's not a wide street. Right now it's a dirt street. It's just dirt. And when you turn, right going towards Hubert, it's even darker there because the trees shade it. So you don't even see, at night, after a couple of drinks, we don't know what they can do. So that's what we've been trying to see if we can work with them and getting help from them to do a gate. We're not saying for them to do everything. We want to, just if they could help us out with that.
All right. Thank you for your testimony. I appreciate it. If you could sign in with the clerk's office. Anyone else that would like to speak in opposition? All right. Seeing no one, county staff, anything further?
No, ma'am.
All right. Mr. Bentley, you have 5 minutes for rebuttal.
Yeah, just a couple issues here. So the burden on the opponents was to demonstrate that the granting of the waiver shall have significant negative impacts on their land. And I appreciate her comments, but they seem to be related to just actual development of the property, not necessarily the sale of alcohol. So if we put a village in there or whatever, this concern about cut-through traffic would probably still exist. So what we intended to do is thank you. My client actually owns.
If you could use the microphone. Thank you.
Thank you, I'm sorry. The client actually owns Perez up to around this point. You can see
So Perez is a private road,
yeah,
correct?
we've granted easements over Perez to all these property owners. And then this little sliver here that connects to Hubert, that's actually has a folio number. You can see that's owned by Hillsborough County. It's unimproved. It's pretty narrow. I don't know how wide it is, maybe 15 feet. But in any event, what we were proposing is we're going to pave Perez, have signage here diverting all our customers into the property. And it's a destination-oriented type use. It's not just like a 7-Eleven where someone's just impulsively going in there. So they'll know the lay of the land quite quickly. So with respect to other improvements such as a gate, we had advised the neighbors, my client did, that these are issues that would be resolved through permitting because you're dealing with life safety issues, whether or not the fire department or fire marshal would allow, putting a gate on Perez and things like that. So we're committed to working with the neighborhood, but we're not at the point right now where we can say what the solution would be for the possibility of some traffic actually,
trying to go north and go over to Hubert. So that's all I can say. But it really doesn't relate to alcohol. It's just flat out development of the subject property.
The private road your client owns goes northeast and then heads in a southerly direction to that county-owned 15-foot strip,
Well,
is that correct?
Ms. Finch, we own, and I'm just ballparking here based on my recollection of the survey, we only own in fee simple Perez up to this point.
Oh, up to your property.
Then it's owned by, I think, someone named Kustra here is my recollection, looking at the title work. And then it goes over here, and then it's owned by the county. And like this lady said, it's unimproved. So all I can do is commit on the record that we're willing to work with the neighbors to find a solution to this speculative or potential problem, but that would happen during permitting because it's kind of a complicated thing, working with the fire marshal to see if you could gate it or what other solutions would be out there.
Let me interrupt you if I can in your time.
Sure.
Mr. Hisney, what is the county's policy or regulation regarding access to those homes that would be prevented or limited by a gate?
I wouldn't be able to answer that question. I'm not familiar with that. Would be a transportation question.
Okay. Mr. Ratliff, lucky you're in the room. If you can, for my own information. Are you familiar with the issue? I know this wasn't part of your...
No, correct. And I've just been, just for the record, James Ratliff, Development Services Transportation. I've just been looking at it while everyone's talking. Certainly there are a lot of private roads that have gates. If it was to have one, it would have to be compliant with TD9, typical detail 9 within the Transportation Technical Manual, which requires a rather wide turnaround area. You know, you'd need to place where vehicles that are turning that way but can't get through have to be able to turn around.
And when typically is that discussion take place? If they were to pursue that, that would be at the site development stage of the review process?
Certainly. I mean, we talk about it at different points in the process. If it's a PD and they're showing a lot of detail and they intend to gate, but they're showing narrow roads, then we'll try to bring it up then, because obviously what they're showing, you know. So there are different, it's not always talked about just at site.
And you'd have to, I would assume you'd have to have agreement of those property owners that are affected by it.
Right. I mean, with regard to it being a private facility, they would have to demonstrate that, you know, there's a right of, you know, whatever easement document gave them the right to make those improvements. And
All right, understood. Thank you for your testimony. I appreciate it. Mr. Bentley.
I think one of the problems here too is this issue about adequacy of right-of-way. For example, Perez, there are private owners on both sides. The county's not going to come in and exercise eminent domain to widen Perez.
Well, that's why I asked the question, frankly,
you
is
know.
that how would that work, and is it even feasible?
Yeah. So, like I said, these are just development-related issues, not necessarily related to the 2 COP waiver, but we will commit on the record, and the client says that they will work with the neighbors to see if that is actually going to be a problem. If it is, they'll work with them to try and find a solution. And here again, that's really up to the county how you address that. That's all we can say. Thank you.
Thank you for your testimony. So with that, we'll close Special Use AB 19-0957 and go to the next case.
Sure.
Next case is item C2, application 19-1136. The applicant is Mohammed and Noreen Azam. The request is a special use for a private school. Staff report and recommendation will be presented by Israel Monsanto.
Is the applicant here? Yes, if you want to come forward, it's your turn. You could give us your name and address to begin. Thank you.
Good evening. John Mueller, 18115 North US Highway 41, Lutz, Florida. I'm here to represent the applicant for a special use for a private school. This site obtained approval in 2016 for a K through 8 school for a total of 39 students. Since that time, some of the students have matured and they would like to open the school up to high school students. They will not be increasing the number of students. It will remain at 39. We have worked closely with staff in regards to working out some circulation and some other issues. and we concur with their staff recommendations, and I'm here to answer any other questions.
I don't have any questions you explained why there's no increase in students, so that was one thing. And then, no, that was it. So I appreciate your testimony. If you could please sign in with the clerk's office. Development Services. Good evening.
Good evening. Israel Monsanto Development Services. I will go to the overhead to put the site plan. As the applicant indicated, this special use is for a private school, which is currently operated under special use permit 160235. The applicant seeks to add a senior high classes. However, the maximum number of students will remain at 39. Since high school students are being added to the school use, this triggers a change in parking calculations. The applicant is proposing to calculate the parking number based on all students being high schools. The site was approved and constructed with a current parking ratio for elementary and junior high school of 1.6 spaces per classroom, which is a total of 10 spaces, including one accessible space. With the high school students, the required parking spaces per the Land Development Code Section 60500 is 0.33 per students plus 1 per staff. Per the data provided by the applicant, for 39 students and 5 staff members, this new formula will require a minimum of 18 spaces, including 1 accessible space. The proposed site plan shows compliance with this requirement. The additional parking spaces are being located on the east side of the current parking lot area of the school. So this is the added parking spaces here. Location of an outdoor recreation area, it's also being shown on the site plan. These recreation areas will not be illuminated. All other standards from the Land Development Code Section 61188 for schools are not being changed since the original special use approval, and no waivers are being requested or needed. Required buffers and screening are being met, and the square footage of the existing school is not changing. Transportation staff has reviewed the request and have indicated that the site plan demonstrates the ability to provide the required permanent and special event parking. These are the event parking being located on the east side of the proposed parking spaces, which is going to be paved. This is the circulation plan. The transportation staff have reviewed the circulation plan and the queuing and the student drop-off and pickup area and find it approvable. An administrative variance to waive improvements on Morris Bridge Road was submitted by the applicant. Given existing roadway conditions and number of trips, the county engineer approved the administrative variance, which originally was dated from February 23rd, 2016, authorizing this deviation from the technical manual typical section. No objections were received from other reviewing agencies, including the Planning Commission, the Environmental Protection Commission, and transportation staff. The proposed use is compatible with the area, with surrounding uses consisting of another private school, K through 12, with a daycare adjacent to the south, farms, and large tracts of residential homes. Based on the above findings, staff finds the request to be approvable, subject to recommended conditions. I'm available if you have any questions.
I don't, but thank you for your testimony. I appreciate it. All right, Planning Commission, please.
Jawan Haley, Planning Commission. The subject property's adopted future land use category is residential 1. The subject property is located within the rural service area. It is not located within the limits of a community plan. The proposed special use for a 39-student private school would allow uses compatible with the surrounding development pattern and allowable within the residential 1 future land use classification. The intent of the residential 1 future land use classification is to designate areas for rural residential uses compatible with short-term agricultural uses, including rural-scale neighborhood commercial, office, and multi-purpose projects. The community design component in the future land use element of the comprehensive plan contains policy direction about designing developments that relate to the predominant character of the surroundings. It further states that new developments should recognize the existing community and be designed in a way that is compatible with the established character of the area. Per future land use element objective 17 and policy 17.1, residential support uses are encouraged to be located in residential areas to support the neighborhood residential population. The proposed special use request for a private school is also comparable to the surrounding development pattern, as residential uses and similar residential support uses are located within the vicinity of the subject site. Overall, the proposed rezoning would allow for a development that is consistent with the goals, objectives, and policies of the Future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County and is compatible with the existing and planned development pattern found in the surrounding area. Based upon these considerations, Planning Commission staff finds the proposed special use consistent with the Future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to conditions proposed by the Development Services Department. Thank you.
Thank you for your testimony. I appreciate it. At this time, we'll call for anyone that would like to speak in support. Anyone in favor? Seeing no one, anyone in opposition? No one. County staff, anything further?
No, ma'am.
All right. The applicant, anything else?
No, ma'am.
Thank you for your testimony. I appreciate it. With that, we'll close special use 19-1136 and go to our last special use case.
That's item C3, application number 19-1290. The applicant is Amy's Kitchen and Food Mart. The request is for a 2 COP alcoholic beverage permit, which requires a distance separation waiver. Staff report and recommendation will be provided by Annie Barnes.
Good evening.
My client's at 1441 East Fletcher Avenue, Suite 133 and 135, Tampa 33612. The business is requesting an extension of premises for suite number 133.
Ms. Liberty, could you put your name and address on the record
Oh,
as well?
I'm sorry.
That's okay.
Dixie Liberty, 13359 Ashbar Court,
Thank you so
Riverview,
much.
Florida. Suite 133 for outside patio. He has also taken the space next door to the east of him, Suite 135, and also the patio out front. At this time, he does have a 2 COP beer and wine on and off premises. This was approved back in May 2015, special use 150819. It was approved. If it's approved, please rescind. Asking for 2 waivers. The first one is the separation requirement of 250 feet. The site residentially zoned property. The residence is approximately 50 feet from behind the strip center. There is no access to the apartments from the rear center. There is a drive, a 6-foot chain link fence, plus some landscaping in between, so you cannot get to it from the back. You would have to go around to the apartment complex. The second one is needing a waiver for 3 or more of the same kind within 1,000 feet. The survey shows that the wet zone parcel is located on Fletcher Avenue, which is a major roadway and a commercial retail center. There is a lot of retail on there on the survey. Every one of them is on Fletcher Avenue. There is going to be outside seating of 842 feet, inside 2458 square feet. The total is going to be 3,300 square feet. You have any other questions?
No, I don't, but thank you for your testimony. I appreciate it. Development Services, please. Good evening.
Good evening. Annie Barnes, Development Services. As the applicant has already stated, this request is for several distance separation waivers for a 2 COP alcoholic beverage permit to allow for the sale and consumption of beer and wine on and off the permitted premises in connection with the proposed expansion of an existing restaurant located in the La Place Shopping Center at 1441 East Fletcher Avenue. There is a residentially zoned property within 50 feet of the proposed wet zoning. The applicant requests a 200-foot distance separation waiver from the 250-foot separation requirement. Additionally, per the wet zone survey, there are more than 3 certain types of AB special uses, or AB wet zoning, excuse me, within 1,000 feet. And that the applicant is requesting to waive that as well. Staff finds that the subject to COP AB special or AB request to be approvable, subject to the recommended condition that the use of the outdoor sidewalk area shall not be obstructed with common passage according to ADA requirements. Approval is based on the wet zone survey reflecting a total wet zone footprint of 3,300 square feet and received August 13th. Additionally, if approved, the existing 2 COP alcoholic beverage permit on the subject premises, SUAB 150819, shall be rescinded.
All right,
And
thank
that
you very
concludes.
much. I appreciate it. All right, is there anyone that would like to speak in favor? Anyone in support? Seeing no one, anyone in opposition to this petition? No one? All right. County staff, anything further?
No, ma'am.
All right. Ms. Liberty?
ma'am.
All right,
Have a
then
good
with
evening.
that, thank you, I appreciate it. We'll close special use 19-1290. And let me go back to Mr. Whitehead for an explanation of your right to speak to the Board of County Commissioners, and that governs your participation. Of particular note will be if you want to speak at the Board of County Commissioners on your item, pay special attention to the party of record filing deadlines and requirements. Mr. Whitehead.
Thank you, Madam Hearing Master. Louis Whitehead, Assistant County Attorney. Tonight's evidentiary hearings are the first of 2 steps in the county's rezoning process. The second step is a public meeting before the board, at which time the board will make a decision on each rezoning petition. The hearing master will file a recommendation for rezoning applications heard tonight on November the 4th. After the recommendations have been filed, each individual who desires to address the board at the public meeting must file an oral argument request no later than the close of business on November the 14th. These petitions are scheduled to be heard by the board at the board's December the 10th land use meeting. Oral argument request forms are available on the table located at the entrance to this auditorium. Please note that oral argument requests must be responsive to the hearing master's recommendation. Accordingly, oral argument requests should not be filed until the hearing master's recommendations have been delivered to the county on November the 14th. The board can hear oral argument from a party of record. A party of record is an individual who fits into at least one of 4 categories set forth in the Land Development Code. In the event that the board elects to hear oral argument, parties of record who will file responsive, timely requests will be considered for oral argument. Oral argument requests should clearly indicate why oral argument is necessary to address at least one of 4 outstanding issues set forth in the Land Development Code. The scope of oral argument shall be limited to the content of the testimony and other evidence submitted verbally or in writing to the hearing master tonight. The board will consider only the record of tonight's hearing and the recommendation of the hearing master in rendering its decision. The county attorney's role is to ensure that only individuals who have met the party of record requirements are allowed to address the board, and that no new evidence or testimony is introduced or allowed at the public meeting. For these records, please ensure that all information that you desire the board to consider at the public meeting is introduced into the record tonight. Thank you very much.
Thank you, Mr. Whitehead. And just want to make sure that this is clear for everyone, not only the next case, but also all of these cases. If you would like to speak to the Board of County Commissioners, the form for oral argument that you have to fill out is right outside the door. Is that correct, Mr. Whitehead?
That's correct.
And what is the filing deadline with the clerk's office that they have to have that in to preserve their right to speak to the board?
November the 14th.
November the 14th. So if you want to speak to the board, you need to fill out the form and submit it to the clerk's office by then when the instructions are on that form, I presume. All right. With that, then, let's call the first remand case, Mr. Grady.
The next item is agenda item B1, rezoning application PD 18-0798. The applicants Johnson, Pope, Boca, Ripple, and Barnes LLP. The request is to rezone from RTC1 to a planned development. I will provide staff presentation after presentation by the applicant.
All right. Is the applicant here? Good evening.
Good evening, Ms. Finch. My name is Mark Bentley, 401 East Jackson Street, Tampa, 33602, and I have been sworn. I represent the property owner, Stephen Kukolich, who's seeking a rezoning from RTC 1 to PD.
Mr. Bentley, could you bring the microphone just a little closer
Yeah,
to you?
okay.
Perfect. Thank you.
Just, can you stop the time a second? Before I get started, I just want to go through the documents that I'm going to submit into the record. At our last hearing last year, I submitted a composite exhibit, had about 30 exhibits. Okay, that's already in the record. I'm going to give you another copy, and on the inside of that binder, there are going to be additional documents that I want submitted into evidence, and they primarily consist of letters in support and affidavits of people you're going to hear tonight testify about the history of the property. Okay?
Okay, perfect.
So my assistant Ashley is dealing
She
with
started
that.
without you.
Yep. So back to the subject property. It consisted of two long-standing land uses at the property of auto sales and auto repair, which occurred from 1986 up to the present time. From 86 to the end of 2012, it was known as Ted's Auto Center, which consisted of auto sales and repair. However, in 2006, the property was rezoned RTC by the county, which prohibited the two land uses at the property of auto sales and auto repair. Notably, at no time between the enactment and the sale of the business in 2012 did the county advise the prior owner that the uses were prohibited. So the point being that from 2006 till the property is sold at the end of 2012, there were no issues with respect to compliance, at least suggested by the county. So prior to filing this rezoning application, we were advised by county staff representatives that they may have a more positive perspective on the application if RTC standards were incorporated to the extent possible into the PD, which we did. And we are providing you with the staff pre-submittal comments in the binder that I just discussed. So our application incorporated RTC standards, though not required as a PD, and we've done everything short of demolishing and relocating the existing building in order to comply. On October 9, 2018, county staff acknowledged our efforts to the Board of County Commissioner when your recommendation was presented to the board, and this is in your backup materials. And Mr. Joe Moreta testified as follows, that our PD meets many of the RTC standards, and I quote Mr. Moreta in front of the board. In the PD proposal, the applicant from a design perspective doesn't significantly deviate from the RTC. In their proposal, at least in our estimation, what it does is it addresses the existing condition, then also establishes how to deal with that if the use has changed in the future. And let me stop right there. What we had proposed as a condition, which is also an exhibit, I think Exhibit 20, is that in the event auto sales ceased, that any redevelopment of the property would fully comply with the RTC standards. Go on to quote Mr. Moreta, we believe in that element of the proposal that the applicant has done a sufficient job of addressing that, but where we deviate in opinion from the applicant is in the issue of use. So as you can see, the staff advised the board that we have sufficiently respected the RTC, and compatibility is not the issue, but the issue is the actual use being excluded from the RTC. So the real issue is inconsistency with this RTC downtown plan, not incompatibility. Because when you think about it, Ms. Finch, auto sales is a permitted use in the CG zoning district, and that's the allowed uses in the RTC or CG, but for certain lists that are prohibited, which includes auto sales, obviously, and auto repair. So regardless how the staff reports dance around the issue of compatibility, staff will agree, hopefully I believe, that since auto sales is a CG use, it is compatible with other CG uses. But staff is opposed because the use is prohibited from the RTC. But the problem with this analysis is that we are seeking a PD to change the use and opt out, yet be compatible with the surrounding land uses and the plan. A use can be prohibited from a special district, but designed in a way to be compatible. If this wasn't a possibility, the staff would have advised us that this is prohibited and wouldn't have encouraged us to incorporate RTC standards and would have probably flat out rejected our application. The points I intend to address tonight are first our efforts for community outreach, which resulted in more supporters, the new staff reports or modifications to the reports, discuss issues of concern in your recommendation to the board, explain compliance with the RTC standards. Our analysis is Exhibit 18 and demonstrates to what extent we comply with the RTC standards. I want to show you and staff where where they have recommended prohibited uses in special zoning districts through the PD process, which is exactly what we are dealing with here. And we want to submit zoning conditions, which are in the binder, and enter support documents. So let's talk about community involvement. Since the BOCC hearing, we met several times with representatives of the Ruskin Community Foundation, and I know they're in attendance tonight, and you'll probably hear from them. They refused to support the rezoning or any modification to LDC that would grandfather the auto sales use in. They feared, from my perspective, that a precedent would be established, even though we agreed to full compliance with the RTC once auto sales ceased. RTC has been a dismal failure since its inception 13 years ago. Only 2 projects have attempted to comply, a new AutoZone and Family Dollar, and neither one could comply with RTC and had to get multiple variances. And we have those in tabs 7, 8, and 9. And to the Ruskin Foundation about precedent has been set, not necessarily through the PD process, but through the ambiguous grandfathering provision that allows any use lawfully in existence in 2006, which is the effective date of the RTC, to remain in perpetuity. So all of these pawn shops, auto repair, and the like will be forever allowed without any amortization or cessation of use provisions similar to a typical non-conforming use in Section 11 of the LDC. So they don't have to comply with design standards either. This includes auto repair for our own site. There hasn't been auto repair for 7 years at our property. But if this application is denied, that use can come back without meeting any RTC standards. It was an existing lawful use upon the effective date, and that's the county's position. However, if our PD is approved, we have agreed to relinquish that vested right to auto repair. So essentially the train's left the station and precedent has been established. Also note, this is an irrefutable fact that if our project is approved, it will be the most RTC compliant redevelopment project in the RTC's 13 years. And I'd appreciate it if you would include that statement if it's not refuted as a finding of fact in your recommendation to the board. The project complies with 7 of 9 sections under the RTC, almost 80%, and that's an analysis we provided under tab 18. It was never intended that the enactment of the RTC would require demolition or relocation of existing buildings. The community would have never agreed to that. And I discussed this with Ms. Council, and I think she agreed with the statement I just made. It was to ensure that redevelopment projects attempt to comply with RTC standards like we are attempting to do. It's kind of interesting, too, when you think about it. If a client wanted to convert our auto repair to a lawyer's office, there is absolutely nothing in the code that requires compliance with the RTC. I challenge staff to show me a code section that requires compliance. We've also met with several individuals who support the project and have observed historically auto sales at the property prior to my client's purchase in the latter part of 2012. So these will be affidavits and letters that I mentioned that will be submitted into the record. I just want to talk about the staff report. Staff fundamentally hasn't really grasped, with all due respect, that we are zoning out of the RTC, and so the RTC is really irrelevant. For example, on page 2, staff says the request is not in compliance with the permitted uses found under the RTC. Obviously, we realize that, and that's why we're rezoning the property. The staff report, section 1.5, page 3, entitled Compatibility, states development services staff finds the proposed rezoning inconsistent with the development pattern in the area. So my question is, how could this be true? All development on page 4 on the graphic are CG uses, and auto sales is a CG use. Also, staff fails to mention all of the uses in the area that are now prohibited in the RTC that can remain in perpetuity and that are compatible with auto sales, which are auto repair shops on 41, lawnmower repair, liquor store, pawn shops, and others. So it appears what staff is apparently intending to say under the guise of incompatibility is not that a CG use, auto sales, is incompatible with other surrounding CG uses from a planning standpoint, but that it is inconsistent with the RTC plan. But here again, that is not the appropriate standard when a petition is seeking a PD. It should be, are the PD uses compatible with what's around it in terms of character and intensity? Staff, I believe, erred also on page 4 when it states that the Family Dollar constructed in 15 met RTC standards. Obviously, to the contrary, it didn't, as it filed 2 variance applications to allow deviations from the RTC standards, and these are at tab 7 and 8. Tab 9 is new auto zone. The only other new project in 13 years on 41 also needed variances from the RTC. Just like to talk about your prior recommendation. You state as a finding of fact on page 8, paragraph 9, that, quote, the planned development district is intended to provide flexibility for design and other characteristics, but not to permit uses that are prohibited by special zoning districts, end quote. This was not a fact for the record, but it appears to be your personal opinion as set forth as a fact, with all due respect. Also note that case number RZ 150678, rezoning from the RDD special district to PD, you endorsed a prohibited use through the PD process and stated in your recommendation that the prohibited use would be compatible, although prohibited, and I'm submitting those documents to you in your binders. So the point is, a prohibited use can still be compatible. We agree with you on that. In this point, auto sales can be compatible, especially when surrounded by other CG uses. Compliance with RTC standards, Exhibit 18, cases where staff and the ZHM recommended prohibited use in specified zoning districts via the PD process. Those are in your documents in the binder, and the proposed conditions are at Exhibit 20. We also have letters in support. I think at tab 10, there's one from the property owner located at the southeast corner of Shell Point in US 41, Rolando Santiago, and there'll be other letters of support. I think they're in your binder. So the final points I want to make are, we can rezone to PD without trying to comply with RTC standards, but we've tried, and Mr. Moreta advised the BOCC positively on this point about our efforts. Second, precedent has been established that PD may be used to introduce a prohibited use into a special district if it can be designed to be compatible like we have done, and like you have recommended in this prior case I alluded to. Auto repair is sanctioned in perpetuity at our client's property, so the residents should strongly consider this when evaluating our project, which would be the most RTC compliant redevelopment project in the history of that regulation. And in terms of support, as I mentioned, Mr. Santiago is the property owner located across the street at the southeast corner. To the north is a restaurant, and they're in support. And the only surrounding property owner that we're aware of who's opposed is Ms. Council, owns the property located directly east of and contiguous to the subject property. So I won't get into it now. I think I used most of my time. And he's not here tonight, but it's Edwin Harwell Jr. They call him the mayor of Baum. But he spent a lot of time down there, and he submitted a letter of support, basically saying that he supports the project, and also that he has bought vehicles from Ted's when it was in business. So he's got an affidavit and a letter in support. And that's it, unless you have any questions.
I do.
Go ahead.
I do. Do you, I looked through your exhibits, and you were reading from Mr. Moreta's testimony at the Board of County Commissioners meeting. Did you submit a copy of that transcript by any chance?
It was in your backup that I got from staff online, but Ashley, do we have a copy we can give?
If it's online, if you have a copy, that would be great. If it's online, I can get it.
Statement. It's in the staff backup.
If it's in the optic system, I can get it.
Ms.
It's fine.
Finch, I think I have it right here.
All right, well, I'll keep going while you're looking. So in preparation for this case, I watched the video of the October 9th hearing. And because the staff report says that the applicant, that the direction back to the zoning hearing master was to further review discussion with representatives of the Ruskin community. And it sounds like you did that you met with members of the Ruskin community, so that's good. Thank you. Is this for me? Okay, thank you so much. I appreciate it. But the board, it was clear from the motion for denial and some of the comments from the board that they were looking for something other than the car sales lot. And I understand and saw your testimony that that was your intent, was to keep the car sales lot as the use. Commissioner Merman said, I look forward to the 30 other uses that are permitted in the RTC. So I just wanted to make sure that I get that on the record, that it's to make sure that I understand it's still your intent to go with the car sales use.
Here's our intent, is to relinquish auto repair, which has been sanctioned, is a lawful use under the RTC, and that's in the conditions, okay? That we would pursue the auto sales as the primary use, okay, and any other use allowed in the RTC, and that in the event auto sales should cease at that property, then any redevelopment would fully comply with the RTC. And let me just kind of clarify, is that in front of the board, they said we're looking for something other than auto sales. And when we kind of regrouped here and met with the community, and we had some very good enlightening discussions and very positive with Ms. Council and members of her development group. But we also found out, just in terms of our outreach, other people who supported the auto sales, okay, and recognized, number one, it had been there, and number two, thought that what was out there was compatible with the surrounding area. So we said, let's just kind of press on with auto sales, because we're getting this kind of grassroots support from the community for that particular use. And Ms. Council, with all due respect, that's just one organization there, okay, that has a certain perspective on what should be on that corner. So that's the way it shook out, and that's what I'm doing here.
All right. Well, thank you very much for your testimony. I appreciate it.
Thank
Development Services, please.
Brian Grady, Hillsborough County Development Services. The applicant is requesting to rezone from RDC 1 Ruskin Town Center to a planned development zoning district to acknowledge as an existing small commercial building and car sales lot to continually utilize the site for that motor vehicle sales, and also to permit other uses permitted under the RTC zoning district found in Land Development Code Section 3.17.00 Ruskin Town Center Development Regulations. As noted by the applicant, there are a number of design requirements that the project is subject to, and there are some that they are unable to meet, and are seeking relief from those, in particular off-street parking standards and also requirements regarding building frontages and building design. The applicant, as noted in their prior testimony and submittals, is seeking relief from those and propose alternative design enhancements to address non-compliance with those standards. However, staff is not supportive of the requested waiver of those design standards. With respect to compatibility, Development Service staff does find the proposed rezoning inconsistent with the development pattern in the area. Per Land Development Code Section 3.1709H, prohibited uses of the Ruskin Town Center, motor vehicle sales, rentals, and auctions, all types, is not a permitted use within any of the special zoning districts established under the development regulations of the Ruskin Town Center. Furthermore, the Ruskin Town Center prohibits other auto-dependent uses such as motor vehicle repairs, recreational vehicle sales, convenience stores with fuel pumps, and mini warehouses. Per adjacent uses to the property in the vicinity are uses that are zone Ruskin Town Center and contain uses that are permitted uses found under the commercial zoning district per LDC section 3.1707 of the Ruskin Town Center regulations, or are in compliance with the Ruskin Town Center regulations consistent with the intent of the RTC 1 zoning district. Existing uses do not include compatible commercial auto-dependent uses prohibited by the RTC 1 district. Shell Point Road resides adjacent to the north of the site with commercial uses across the street. A commercial restaurant is adjacent and south of the site. US 41 is adjacent east of the site. Commercial uses including a Family Dollar are across the street. A vacant lot with shed on it resides adjacent west of the site. Given the established development pattern of the area, which consists of uses consistent with the intent and requirements of the RTC 1 district, staff does not find the proposed motor vehicle sales use compatible. Again, from our perspective, I understand Mr. Bentley's contention that since the RTC allows CG uses, and we shouldn't be looking at the RTC, but again, like any other zoning district, as part of any other compatibility analysis, you obviously look at the surrounding zoning pattern and see what uses are and aren't permitted. And so, given the fact that within the RTC this is not a permitted use, and again, as analyzed here, the presence of not is not in that area, we from a compatibility standpoint found it not compatible.
All right, thank you very much. Planning Commission, please.
Jawan Haley, Planning Commission. The subject property's adopted future land use category is Office Commercial 20. The subject property is located within the urban service area. It is within the limits of the Ruskin South Shore Area-Wide Systems Community Plan. The site is developed with a motor vehicle sales business consisting of a 1,848 square foot building and inventory displayed mainly along the frontage of Shell Point Road and US Highway 41. The surrounding uses in the area include a fast food restaurant to the south, vacant parcels to the west, east, and a real estate office north of the site. The rezoning request is to change the Ruskin Town Center 1 zoning district to a planned development, to recognize the existing motor vehicle sales business and allow other RTC 1 permitted uses. It should be noted that the site underwent a zoning verification in 2014, and it was determined by the Development Services Department that the site failed to establish that motor vehicle sales was an existing lawful use, and at the time of the establishment of the Ruskin Town Center 1 zoning district. Policy 9.2 of the future land use element states that developments must meet or exceed land development regulations. As shown on the site plan, the request is not meeting the intent of this policy. The site is located within the limits of the Ruskin Community Plan and within the Ruskin downtown. There is specific language within the community plan that expresses how development within the downtown should be designed. Because the parking fronts the site and is a dominant portion of the site, this creates the look of a strip commercial development. Objective 23 of the future land use element, as well as the Ruskin Community Plan, discourages strip commercial development. The applicant did attempt to make changes to address the design of the site to further the intent of the Ruskin Community Plan. Fences within the RTC 1 area are to be made of masonry or vinyl or cast iron, so the applicant has agreed to remove the chain link fence that is currently on the site. The applicant is also providing additional screening and an awning above the cars along Shell Point Road and US Highway 41 to reduce the appearance of the display of cars. Though the applicant is providing increased screening along the frontage of the site, screening and waste storage and mechanical equipment, the proposed design of the site is still too much of a deviation from the Ruskin Community Plan. And based upon these considerations, Planning Commission staff finds the proposed plan development inconsistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you.
Thank you very much. We'll call it this time for anyone that would like to speak in support. Anyone in favor of the application? Yes, if you could please come forward. If everyone who wants to speak in favor, if you could go ahead and come forward to line up, it speeds everything up. How many people would like to speak? 3? 3, okay. Then you have 15 minutes. We'll give you 5 minutes each. And whoever would like it to go first is welcome to. Good evening. You could give us your name and address to start.
My name is Ted Pieta. I live at 2008 Heathfield Circle, Sun City Center, Florida, 33573. And I am the former owner of the property in question on 108 North US Highway 41 in Ruskin. My business operations consisted of auto repair and auto sales. I was in existence from approximately December of '86 to December of 2012. During this time, I attended auto auctions on a monthly basis. My wife came to a few of them with me also. At these auctions, I would purchase vehicles and then resell them to the general public. At all times, the car sales side of my business was licensed to sell automobiles by the State of Florida Department of Motor Vehicles. And I sold automobiles as a significant component of my business. And I would like to add that the Florida Department of Motor Vehicles, the very epitome of dotted I's and crossed T's, don't have any record of my dealer's license the number of which was VI 15189, that I had for over a decade. They have no record of that. The state of Florida DMV required, under the Florida Administrative Code, that I maintain an office clearly separated from the auto repair that had to have a separate entrance, and I complied with that at all times. I sold the property to Mr. Stephen Kuklich on or about December 13th, 2012, and at that time, I was retailing automobiles. On or about November 2nd, 2006, Hillsborough County changed the zoning for the property from CG to RTC1 to prohibit both motor vehicle sales and repair. The zoning change was never made known to me by the county, as it did not provide direct notice of the zoning change. And I continued to sell automobiles pretty much right up until the end, when I sold the property to Mr. Kuklich. And all of my business records, including licenses with the county and the state and the DMV, apparently were purged after the sale of the property. But I was in there for a lot of years, and I was never once cited by Hillsborough County for improper use, never. And that's what I wanted to say, that there were, in fact, legal car sales going on all the time.
Thank you for your testimony and coming down. If you could please sign in. Next, please. Good evening.
Hi, I'm Donna Pieta. I live at 2008 Heathfield Circle, Sun City Center. I am Ted's wife for 48 years now, and I agree with everything that he said, but I'm sorry. He was been in existence since like 86 to 2012, and during this time I assisted in the office. I went to auctions with him, bought cars, and things like that. I'm sorry, I'm very nervous.
Oh, don't worry. No one's watching. It's okay.
Everybody's watching me. At all times during the existence of Ted's, the car sales side of the business was licensed to sell automobiles by the state of Florida Department of Motor Vehicles, and sold automobiles as a significant component of the business. We sold the property to Mr. Kuklich in December of 2012. And we were never notified of the change to prohibit both auto sales and auto repair. The zoning change was never made known to us by the county, and Ted continued to sell automobiles after November 2nd, 2006, until the sale of property to Mr. Kuklich, and was never cited for this activity by Hillsborough County. At all times, Ted sold motor vehicles at the property.
Thank you for coming down. Appreciate it. If you could sign in. Yes, sir. Good evening.
My name is Lee Davis. I live at 308 14th Street Southwest, Ruskin. I worked for Ted in 1986 and 1991, and this business was selling cars and auto repair. I own At Home Auto Care in Ruskin today. And as long as I've been there, Ted has always been selling cars at that same property. That's about what I have. Okay.
Thank you for coming down. I appreciate your testimony. Thank you, sir. If you could please sign in. All right, we'll close the testimony in support, and we'll call for anyone that would like to speak in opposition to this application. Anyone opposed that would like to testify? All right. Good evening.
Good evening. Sandra R. Council, P.O. Box 1115, Ruskin, Florida 33575. I'm going to speak. I'm president of the Ruskin Community Development Foundation, but I'm going to speak as the adjacent property owner and relinquish my time for the foundation to Mr. Chris Bedbiner.
Okay.
As the adjacent property owner, in due respect to Ted and his wife and to Mr. Davis, I had specific conversations with Ted, asked about the non-conforming use, that it was not allowed use at car sales. And his response to myself and to my business partner was that he did not sell cars there. that he had other property that he sold cars from. The cars that were sitting there were cars that had been abandoned for non-payment for repair bills. So that's my recollection of a conversation, as well as my business partner's conversation. So I'm in support of staff's recommendation to deny.
Thank you so much. If you could please sign in. Yes, sir.
May I do this? You already have it on record. It's a letter from the Community Foundation.
All right, you can submit it to the clerk's office and I'll get it. Absolutely.
William Bredbenner, B-R-E-D-B-E-N-N-E-R. I am here representing 109 2nd Street, Northwest, Ruskin, Florida.
Thank you.
I am a resident, but here representing the Ruskin Community Development Foundation, a volunteer board that was formed years ago. As Sandy mentioned, she is our president. I am a board member and speaking for the board. We applaud Mr. Kuklich and Mr. Bentley working with us. We have met once with them on October 25th to review. They came down and met with us to see if, after the remand came through, to see if there were any ways to work through this. And then we also met on January 25th, or excuse me, yes, January 25th with county staff to see what could be done and even explore a letter of carve out, so to speak, for it. Our issue is definitely not with a business coming in there. That's what we want to do, is to develop the Ruskin community. Using that, we really couldn't find a way to do it and still preserve the intent of RTC 1 and 2 by carving that out, and would allow for, yes, the precedent that Mr. Bentley does speak of now anyone wanting to do something outside of that to come in and carve out a PD for themselves. So I would disagree with the claim, his opinion, that it would be the most compliant. I think if this were to pass, it would probably be the last compliant project in RTC. So because no one will need to follow the rules if we can carve this out. So we are worried about that precedent. The board did meet after our meeting with county staff, where it couldn't be determined that we, in fact, we could go through the process. There was a lot more to it, and we submitted, again, our vote that we still continue to support this board's decision that it is not consistent and that it should be moved forward by the county commissioners as not consistent. Thank you.
Thank you for your time. I appreciate it. Anyone else that would like to speak in opposition? Sir, if you could please sign in. Thank you. All right, then we'll close that portion of the testimony. Mr. Grady, anything further?
Nothing further. Just wanted, for those who spoke in support or in opposition, that if they have questions regarding filing oral argument, Fernanda Quinones is in the back of the room here and can answer any questions.
So we
they
do
may
have a
on that.
staff person available. All right, perfect. All right, Mr. Bentley, you have 5 minutes for rebuttal.
I'm going to request a couple additional minutes. First of all, I'm waiting for Mr. Pieta to come down. I want to use him on rebuttal.
Okay, absolutely.
Ted, your name and address again, please.
My name is Ted Pieta. I live at 2008 Heathfield Circle, Sun City Center, Florida.
Ted, you heard what Ms. Counsel had to say about her conversation with you. Would you elaborate on that?
Mr. Bentley, you speak into the microphone.
Can you grab the microphone if you're going to do that as well?
Well, I really can't elaborate on that because I don't have any recollection of that conversation whatsoever. And I realize my memory's not what it used to be, but I think I would have remembered that one. I can remember my dealer's license, and I can't remember what I had to eat yesterday. You know, that's all I can tell you.
Thank you.
Sold salvage cars or something.
Mr. Bentley, Mr. Bentley, you need to be on the record.
Okay, thanks, Ted. That'll do it.
Thank you, sir.
Yeah, we're good. Thank you. Just a couple points is not to relitigate the zoning interpretation, but that interpretation related to a different set of facts and also the issue, and it's set forth in the staff report. And this is our bone of contention, is the RTC says any existing lawful use in existence upon the effective date of this ordinance shall be considered a lawful use, end of story. It doesn't say whether it's subordinate or accessory or principal. So if you look at page 2 of the staff report, They say a zoning interpretation was issued, et cetera, and they give the number. It says to recognize vehicle sales as the principal use of the property. We never alleged that. We always alleged that it was subordinate or accessory. So this is the fundamental issue here, the misapplication of the code, okay, that this was the principal use of the property. So I didn't want to relitigate that zoning interpretation, and from our perspective, that was 4 years ago. We have a different set of facts here. We beat the pavement and found a lot of people who actually dealt with Ted, and you heard him testify today, and the issue is not the principal use. And you're required under your the criteria is a LUHO to consider the history of the property. I think that's the first enumerated criteria. So much for that. Then Brian indicated that we were seeking relief from the RTC, and with all due respect to Brian, we were not seeking relief from the RTC. We're rezoning to PD. We're not seeking a waiver or variance from the RTC. So I just want that corrected in the record, that there's no relief from the RTC. Then in terms of, would it be appropriate at this point where I can ask the staff a couple questions?
You have 2 minutes. Sure. This is part of your rebuttal period.
Okay. So Brian, I just have a couple questions for you. First, auto sales is a permitted use under the CG zoning district, correct?
Correct.
So presumably auto sales would be considered compatible with other CG uses, correct?
In other CG zoning districts, in a vacuum, yes.
Okay, the subject property has several CG uses, either contiguous to or in close proximity to it, correct? It's page 4 of your report.
Similar, yes, CG use is correct.
Okay, so assuming auto sales wasn't prohibited under the RTC, your opinion would be that it is compatible with the surrounding land uses, correct?
In a vacuum, if you had an area that has CG zoning districts in an area, and then you came in to do a CG zoning district with similar uses, generally, I would say that in that vacuum, we would find, CG adjacent to a CG compatible.
Okay, so assuming that the RTC was not applicable in this situation, the subject property as it relates to surrounding zonings and land uses that are primarily CG would be compatible, correct?
If I understand your question, you're saying not considering the RTC use issue, if you're looking at a CG against a CG, those being compatible, yes.
Okay, thank you. And then a couple questions for the Planning Commission, then I'll be done, Ms. Finch.
Thank you.
And Ms. Haley, did you author the report that's in the backup? Planning Commission report?
180798, that report?
Yes, ma'am.
Is correct. No, I did not.
Okay. On page 3, there's two elements of the Ruskin Community Plan that are set forth with their goals. Can you pull out your report and identify either a goal or a strategy that the proposed rezoning is in conflict with? It starts with livable communities, Ruskin Community Plan.
So there are several bullet points below goal 1.
Yep.
So it says encourage commercial development and redevelopment within downtown Ruskin and the town center, and direct commercial development away from Shell Point Road and Shell Point Road West and 19th Avenue Northwest. I'm sorry, that's the end of
And
my
then
comment.
goal 2 on page 4, would you mind taking a look at that?
Sure. Yes, goal 2 states economic development, provide opportunities for business growth and jobs in the Ruskin community, promote commercial development at a scale and design that reflects the character of the community, ensure that future commercial development avoids strip development patterns. This goal 1 and goal 2 were addressed in the report concerning the strip commercial development.
Okay, so you in your professional opinion, the auto sales is considered strip development?
The staff report states that.
I said, in your professional opinion, is auto sales strip development?
Mr. Bentley, she's testified.
Okay, just yes or no. That's all.
Mr. Bentley, she's filed the report. She testified she didn't write the report, and she's answered your question.
Oh,
If you
okay.
could please conclude your rebuttal.
Okay. That'll do it. Thank you very much.
Thank you for your testimony. Then with that, we'll close rezoning PD 18-0798 and go to the second remand case.
Next item is agenda item B2, rezoning application PD-19-0613. The applicant's Preston Price. The request is rezone from agricultural rural to planned development. I'll provide staff presentation after presentation by the applicant.
Is the applicant here? Yeah. Oh, good evening.
Yes, my name is Preston Price. My address is P.O. Box 4961, Plant City, Florida 33567. I'm here to revise our last PD rezoning so it becomes compatible and consistent with Land Development Code and the comprehensive plan of the county. With that, we just want to include the dog kennels in the PD and the storage on the back of the property. And I can show you a couple of the pictures. As you recall, they built the dog kennels already without a permit. But I will show you, I'll go over to the monitor and show you the proposed.
I see it. It's not up on your screen yet.
Okay. So if you see back here, that's the proposed storage shed in the back. And that's on the back of the property. But more importantly, the dog kennel.
There is something covering the.
He needs a folded paper. He needs a folded bag.
Oh, okay. They didn't have this when I was in school. Okay, so the dog kennels right here. Again, there are 2 kennels that house 7 dogs each, so a total of 14. And my client has had those dogs ever since they bought the property back in approximately May of 2017. And they were strategically placed to limit so here's the property, and here's the dog kennels right now, to limit any to make the surrounding neighbors, you know, the best location, so it doesn't impede, or the noise or anything doesn't impede their living conditions. So you can see the dog kennels will be right there. The next house is right here, and you can't even see the other, and the next property next to them where the dog kennels are vacant. But next to it is wooded area, so I would assume if they would build, they'd build on the front of their property, not next to the dog kennels.
The issue, if I could just interrupt you, if you don't mind, the issue, I had a couple of questions, if you don't mind, to focus the presentation on why it has come back. And if you could just make that still clear on the record, why the application, why you asked for it to come back to the zoning hearing master.
So there was a misunderstanding between Charles and I originally, so we had requested that they have a residence, build another residence on the property as well. We've removed that on the PD rezoning. And also there was a little confusion with what adoption meant for the dogs. And my client, the dogs are going to be for personal use only. They will not sell them, foster them, adopt them out, or anything. It's just personal use only.
All right, so the second home and the adoption issue is cleared up as a part of your the remand.
The
I
remand,
see.
yes, ma'am.
Okay. All right, continue. I'm sorry.
Okay, that's it.
Oh, all right. Talk to me about At the last hearing, there was a number of people in opposition due to the noise generated by the kennels, and I understand you went through where the kennels are in proximity to those residents. Have you thought of anything that could mitigate the noise issue?
So, as we last checked, there has been no documented complaints with Hillsborough County Sheriff's Department or Animal Control. And like I said, the clients, when they bought that property back in May of 2017, have had the dogs there the entire time. So, again, the kennels that are there now, they are caged kennels, and within that, the perimeter of the cage kennels, there is another chain link fence so the dogs cannot roam free on the property. So they are confined to a certain area of the property. Even when they're let out, they're still confined to a certain area of the property. And as far as the placement of the kennels, that was to mitigate the sound to any of the adjacent property owners, because that was the best location in their mind to place the kennels.
Have you tried to meet with those neighbors since the last hearing?
I have not heard anything from the neighbors since the last meeting, no.
And have you reached out to them?
I have not.
Okay.
Other than the reapplication and the filing of the letter.
The notice
to them.
letters?
Yeah.
Understood.
And I did receive one phone call, and the lady just had a question of what we were doing with the property, and I let her know what I just told you with the kennels and the storage on the back of the property.
All right, thank you for your
So I've
testimony.
had no other calls complaining or not complaining.
All right, perfect. Thank you for your testimony. If you could please sign in. Development Services.
Brian Grady, Hillsborough County Development Services. The applicant is requesting to rezone from agricultural rural to planned development. The applicant is requesting the following: to permit an existing single-family detached residence and accessory kennel and agricultural open storage uses. The applicant has indicated the kennels will be kept for personal use and the animals will not be sold or adopted. Development Services staff finds the proposed rezoning is consistent with the development pattern in the area. The property surrounding site are comprised of agricultural and large tract single-family residential uses ranging from 2.5 to 12 acres. Per the Land Development Code, Section 20202, allowable uses in zoning districts. Single-family conventional dwellings are permitted use in the AR zoning district. A private kennel not to be used for sale or adoption in 2/3 parties is also permitted use. Accessory agricultural-related open storage is conditionally permitted, subject to applicable section of the LDC. Given the established development pattern in the area and the proposed uses are allowable under surrounding zoning districts, the proposal would serve as an appropriate infill development incompatible with the area. Therefore, staff finds the request approvable. Happy to answer any questions.
No, I just wanted to double check that because the staff report doesn't have a recommendation at the bottom. I assumed that you were supporting it, but I just wanted to put that on the record that
Yes,
you are recommending approval.
sorry about that. Well,
No problem.
it's on the last page. It got misordered, so it's there. It's just on the last page after the conditions.
Maybe it is, I
Yes,
see, it skips
yes.
the conditions. All right, perfect.
Yes.
Thank you so much. Planning Commission.
Jawan Haley, Planning Commission. The subject property's adopted future land use category is agricultural rural, 1 dwelling unit per 5 gross acres. The subject property is located in the rural service area. The property is not within the limits of a community plan. The proposed plan development is an allowable use within and is consistent with the agricultural rural 1 dwelling unit per 5 acres future land use designation. The application is proposing 2 dog kennels totaling 14 cages. Dog kennels are defined within the Land Development Code as an accessory agricultural use. Some of the typical uses within agricultural rural 1 dwelling unit per 5 gross acres future land use designation include mining activities and feedlots. So the intensity of some of the other allowable uses within the future land use designation may be more intense than what is being proposed within this application. The subject site is within an area where the primary uses in the surrounding area are agricultural and residential uses. Proposed conditions will ensure the scale and design of the site is compatible with the surrounding area. The applicant is meeting the Land Development Code regulations regarding setbacks, which would be meeting the intent of Policy 9.2 to remain compatible with the surrounding development pattern. A condition has been added ensuring that the site cannot be used as a commercial use in the future. Based upon these considerations, Plan Commission staff finds the proposed plan development consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to conditions proposed by the Development Services Department. Thank you.
Thank you so much. Is there anyone that would like to speak in support? Anyone in favor? Seeing no one, anyone in opposition? Yes, ma'am. While she's coming up, is there anyone else that would like to speak in opposition? Okay. Good evening.
My name is Rose Curl. I live at 4605 Bruton Road, Plant City, Florida 33565. Our farm is on the south side of Bruton Road, directly across from the applicant's residence, which is north of Bruton Road. You know, we've lived there for about 35, 40 years. And you want to be good neighbors. You don't want to complain when your children wake up in the middle of the night because dogs are howling. But if I have to do that, I will. But I don't want to. I want to be a good neighbor. These neighbors bought this property recently, within the last couple of years. They knew what the zoning was at that time. And now they're just trying to stretch it. They built kennels without a permit. Now they're talking about another residence there. So I encourage you to view the first video when we had our first meeting. It seems like we've had lots of continuances and lots of postponements. We've now been up here about 4 times. I want good neighbors, but I want good neighbors that live within what the requirements are. Is it permitted that a second house be built?
Let me just stop you just for the clarification of the
Okay.
record. The applicant did withdraw the request to build the second house.
Okay,
So they are not going to do that.
Once the zoning is changed, then are they permitted to decide 5 years from now to build a second house?
According to the staff report and the acreage, that it would only support 1 home. Is that correct, Mr. Grady? I thought that was the issue originally, that there was insufficient acreage to have 2 homes on the property.
Correct.
Yes, so only 1 home could be built on that property.
Okay. And under planned development, it doesn't change. Once the zoning changes, they can't decide 5 years from now to build that second home.
Mr. Grady, let me have you answer that question.
They're regulated under the conditions of the plan development, which would limit them to 1 home as indicated, given the acreage in the future land use comprehensive plan that they're under. They could only do the 1 home on the property. In any event, if the zoning were approved, if they wanted to make a change to the zoning, they would have to come back through the public hearing process through a notice public hearing. So any changes would require another public hearing, and you would be notified of that.
Okay. So I guess your advice to me is, when I hear all that noise, full moon, I'm sure we'll have it tonight, I need to call
I'm not in a
the
position to
complaint?
advise you of anything, just to be clear with that. We're here to
Okay.
take your testimony.
So so I just call the police department. I do have a letter. We have a neighbor that lives to the east of us. Their names are John and Mary Batchend, and they were not able to come tonight, but they asked me to bring this letter.
Absolutely. You can submit that into the record.
Okay. Thank you.
Thank you for coming down. I appreciate it. If you could sign in as well. Anyone else that would like to speak in opposition? All right. Seeing no one. County staff, anything further?
Nothing further. I would again note for the record for those who spoke that if they had any questions regarding filing an oral argument, Fernando Quinones with
To be able
county
to
staff
speak to
is
the Board of
available-
County
yeah,
Commissioners.
is available to answer any questions regarding filing oral argument to speak to the Board of County Commissioners. Thank you.
All right. Thank you so much. Sir, it's your turn for rebuttal if you'd like. 5 minutes. Yes, if you could. You don't need to put your address, just your name.
Preston Price. Again, as far as the dogs are concerned, my clients, they live the closest to the animals. So if there's an issue with them, they don't want to sleep through. They have children also. They don't want to sleep through howling or barking. If there's any, I can't speak to whether there is or not. But again, whether the PD's approved or not, and the kennels have to come down or they stay up, my clients aren't going to, nor do they have to, according to the zoning right now, going to get rid of their animals. So I think it's better that they're confined to a certain area of the property versus being able to run free on approximately 7.5 acres.
All right, thank you very much. Then with that, we will close rezoning PD 19-0613 and go to the next case.
The next item is agenda item D1, rezoning application 19-0793. The applicant is John D. Hooker. The request is rezoned from residential single-family conventional 2 to commercial neighborhood. Laura Marley will provide staff recommendation after presentation by the applicant.
Good evening.
Good evening. John Hooker, 13610 U.S. Highway 92 East, Dover, Florida 33527. Here this evening to request that we rezone one of the parcels of property that we own at this location to CN, which will be compatible to the same zoning that we have on the other parcels at that corner of Fritzky Road and US 92. If you're not familiar with where this is located, we have a convenience store at the corner of Fritzky Road and US 92 East, and then adjacent to that is a parcel. It has its folio number, is an office, and the property in question here is the parcel just to the east of that. And what we're trying to do is to make it all consistent there. I want to point out that it's within 300 feet of the intersection. This is a kind of an anomaly, I guess you'd say, that Fritzky Road starts out at Knights Griffin as Cooper Road, and then it runs and changes to Fritzky Road. And it dead ends there, but then it veers over to the right about a half mile and turns back into Moore Lake Road. And then it turns into North Dover Road and South Dover Road and Little Road, ending at Bloomingdale. The road would run straight if it wasn't for Moore Lake, which sits just south of the intersection there. At the present time, and the reason we're here is that our family has owned this property since 1995. The property in question since about 1996 or 97. And my father purchased it and has improved it. About 18 years ago, there was a couple businesses started on the property. There's a tortilleria business, which is mostly a commercial takeout delivery. They just manufacture the bread. And then, then beside that is a small barbecue place, which is basically takeout or eat in the front. It's not a closed structure. There's about 10 to 12 people that work there and have been working there for the past 15 to 18 years. So it's critical that we come into compliance and have this rezoned from the RSC2 to the CN. To my knowledge, there hasn't been any complaints about it up until about 3 or 4 months ago when somebody made a complaint that doesn't even live in the area, as I understand it. So with that said, that's what we're requesting.
All right, thank you so much. I appreciate your testimony. If you could please sign in. All right, Development Services. Good evening.
Good evening, Laura Marley, Development Services. As the applicant stated, this is to rezone 1.35 acres from RSC2 to CN commercial neighborhood. On the property now, there are approximately 4 unpermitted structures. There is a code violation on the property for improper use. It appears at some point the adjacent property, which is CN, owned by the applicant, they started to construct these structures on the property to the east. So there are at least 2 businesses currently functioning on the property. The applicant is requesting the rezoning to potentially put this site into compliance, although the surrounding area, all lots with the exception of the one to the west, which is CN, is all residential. There's homes on all of the sites adjacent to it. And due to this full range of what's being requested for CN uses, staff finds it incompatible. It would allow intrusion into the neighborhood. What's there currently, it would allow more commercial into the neighborhood, simply because there's a mobile home there now, and in the front there's more of a commercial use. So with that, any potential commercial that would be encroached, we should look at it more as more compatible uses that may be commercial, that would not have the traffic generation, noise, lighting, that type of thing. So it also has been explained to the applicant that this is one of the processes to start putting it to compliance, but they would have to do site development, they would have to do building permits, they would have to meet fire marshal requirements, etc. So due to the concerns stated here and found in the staff report, staff finds the request to be not supportable.
All right, thank you for your testimony. Appreciate it. Planning Commission.
Jawan Haley, Planning Commission. The subject property's adopted future land use category is residential 2. The subject property is located within the rural service area. It is not within the limits of a community plan. The applicant is requesting to rezone the subject property from residential single-family conventional or RSC2 to commercial neighborhood. The site is located immediately north of East Highway 92 and east of Fritzky Road and US Highway 92. The property does meet commercial locational criteria. However, locational criteria is not the only method utilized to determine if commercial development proposals will help to maintain the character of an existing development. The locational criteria outlined in policy 22.2 are not the only factors to be considered for approval of a neighborhood commercial or office use and proposed activity centers. Considerations involving land use compatibility, adequacy, and availability of public services, environmental impacts, adopted service levels of affected roadways, and other policies of the comprehensive plan and zoning regulations would carry more weight than the locational criteria in the approval of the potential neighborhood commercial use in an activity center. The locational criteria would only designate locations that would be considered, and they in no way guarantee the approval of a particular neighborhood commercial or office use in a possible activity center. The application requests commercial neighborhood uses. Single-family lots are located to the east and northwest of the subject property. According to policy 16.10, compatibility is defined as the characteristics of different uses or activities or design which allow them to be located near or adjacent to each other in harmony. Compatibility does not mean the same as, rather it refers to the sensitivity of development proposals in maintaining the character of existing development. The proposed commercial neighborhood uses would be out of character for this area and would facilitate further encroachment into the existing low-density residential adjacent properties. Overall, the proposed rezoning would allow for development that is not consistent with the goals, objectives, and policies of the future land use element of the unincorporated Hillsborough County Comprehensive Plan. The rezoning request is incompatible with the existing residential development pattern and would facilitate development that is out of character with the surrounding area. Based upon these considerations, the Planning Commission staff finds the proposed rezoning inconsistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you.
Thank you so much for your testimony. We'll call for anyone that would like to speak in support. Anyone in favor? Seeing no one. Anyone in opposition to the application? Yes, sir. Did you want to speak in support or in opposition? Okay, if you could please come forward. Anyone else that would like to speak in opposition? All right. Just give us your name and address to start. Thank you.
My name is Donald Kelly, and the address is 4522 Swinger Road in Dover. My property that I bought in 1995 is east of the property that Mr. Hooker's talking about. My backyard, 150 plus feet, is adjacent to his property, okay? And I understand the situation because you folks are planning to expand the width of Highway 92, and it's going to probably take over some property there, and I understand that situation. But we're talking about moving 2 or 4 businesses back even further into the residential area. There's a house directly behind me over on the other side of Mr. Kirk's property, and these buildings would have to be moved right in our backyard, basically. And I've looked through the papers that are on your website, and some of the things that the young lady read here are mentioned. But I just want to point out that it says that some of these are in code violation, and the structures will be moved even further north, and that's the direction. We've had some problems, and Mr. Hooker's well aware of several of them, that we had to call the police on the noise. The mariachi band playing. We've had them go past midnight. We've had them open up at 5 o'clock in the morning, and there's 2 residential houses, mine and one on the south, but the south one is rented, so they don't save much. But we have called the police on several occasions, and if you check that, you'll see the record of it. And I see here where the comprehensive plan talks about it, but it says that it's with the noise, and we've had noise with cars coming in with the loud bass playing and beating, and it's hard to control. But it's a high traffic area, picking up stuff there, and like I said, you're pushing those facilities all the way back in further north to be more in my backyard than it is from, off to my southwest area. And the staff recommended here, according to this piece of paper, that it was not supportable, and that was a county, okay? And it says recommendation is based upon the above consideration. Planning Commission staff finds the proposal inconsistent. And with these violations that we talked about, I find it very hard to understand that these things are going on, and with the problems and the noise that's documented with the police department, and that you would even think of taking it another 100-something feet of his own property and put it in between. There'll be houses, 4 houses be right in that zone, 2 on my west side, and the 2 up there in next to me. And I thank you very much for your
Thank
time.
you for coming down in your testimony. If you could please sign in with the clerk's office. Anyone else that would like to speak in opposition? All right, seeing no, oh. Yes, if you could please sign in. County staff, anything further?
Nothing further, just to add that if the gentleman who spoke has questions regarding filing of oral argument in order to speak to Board of County Commissioners, Fernando Quinones is here to answer any questions you might have.
Perfect. Thank you so much. Sir, you have 5 minutes for rebuttal.
Thank you. John Hooker. Let me point out a couple of things. First of all, they are going to widen US 92. I don't know when they're going to do that. We've received notification about that. They're widening Martin Luther King, which is south of us, and then I assume that when they get the funding, it'll be 92 they'll be widening. And they will be taking some of the property, some of our property, to expand 92, but it won't affect this property and these businesses because they're back far enough away that it's not going to affect them. In regard to the businesses there, they close at 7 o'clock. In regard to the noise factor, I've been monitoring that, and the noise that he refers to is not from the businesses, but it's from private parties that the families that run the businesses there have for their own self, birthday parties, etc. And I have monitored that and working on eliminating that noise factor. And I don't believe in the last several months there's been any noise out there. In regard to the violations, there's just this one violation right now. And these buildings are not permanent buildings. They were built as temporary buildings that are there. And if there is a problem with them, we will certainly do whatever is necessary to make them come into compliance. Again, I would say there's about 12 people there that depend on this for a living that have been working there, and they have no other place to go. And they've looked and to move their businesses, but they don't have any other place to go. With that said, one additional factor is that this particular neighborhood, it's interesting because Swinger Road, which my neighbor there lives on, and Fritzky Road, the houses are along both of those roads, but right down the middle of them, for a space about 155 feet wide, is empty. And some people have a big backyard and some people don't have such a big backyard. So in our property backs up to this strip where there's no houses. These particular businesses are located on the west side of the property, and we don't have any intention of building anything else or expanding backwards from where we're at. We're just trying to come into compliance and preserve the jobs that these people have there.
Thank you for your testimony. Appreciate it. With that, we'll close rezoning 19-0793. Given the hour, I think it's appropriate to take a 5-minute break.
Okay.
The clock on the back of the room is probably 15 minutes slow, so we'll go by the digital clock. So if you could be back at 8:15, we'd appreciate it. We'll adjourn for 5 minutes. Thank you.